The morning my wife told the court I had never built anything in our marriage, I was sitting close enough to hear the faint click of her bracelet against the table every time she moved her hand. It was a plain room, beige walls, cold air from a vent somewhere above us. A paper cup of courthouse coffee had already gone lukewarm by my elbow. She leaned toward the microphone and said it in a steady voice, like she had practiced saying it without heat. That I had earned a paycheck, yes, but that I had never really built anything. Not the home, not the savings, not the life we had lived. Her lawyer gave a small nod as if that settled it. My attorney, a quiet man named Russell, wrote something on his yellow pad and turned it toward me. It said, "Do you want to respond?" I looked at the words, then at my wife, and I shook my head once. I did not feel angry in that moment. Not outwardly. I just sat there and listened to her talk about 30 years as if I had drifted through them half awake. The judge watched me for a second longer than most people do. A week earlier, I had opened a file in my study and found a photocopy of a storage unit contract with a name on it I almost recognized. At the time, I put the paper back in the folder and said nothing. That is where this really starts. When I met my wife, her name was Natalie, though back then most people called her Tally. She was 26. I was 32. We met at a hotel conference outside Denver where she was helping run the registration table, and I was there for work I had no interest in describing to strangers. She had a way of listening that made you think you had said something worth hearing. I remember that first. I remember the sound of rolling suitcases over tile in the lobby, the smell of coffee that had been sitting on a warmer too long, her laugh, low and quick, when I misplaced my badge and she found it sitting right in front of me. We were married 13 months later in her sister's backyard in Albuquerque. White folding chairs, a rented arch with roses that looked real from a distance. My mother dabbed her eyes through the whole ceremony, even though she had promised she would not. For a long time, our life looked solid from the outside because in many ways it was. We had 2 children, Evan first, and then Lila not quite 2 years later. We bought a house outside Kansas City on a street with maples in the front yards and mailboxes that all leaned a little to one side by winter. The schools were good. There was a green belt behind the neighborhood where I used to walk with the kids on Saturday mornings so Natalie could sleep an extra hour. She worked part-time when the children were small. Later she moved into full-time work and then into consulting. She was organized in a way I never was. She kept calendars straight, knew when insurance papers had to be signed, remembered which plumber had come out last time and what he had charged. She was good with timing, good with details, good with people when she wanted to be. I admired that. I relied on it too much. I traveled for work for years. Monday morning flights, Thursday night returns, Midwestern airports, rental cars, hotel hallways with the same patterned carpet no matter what state you were in. When I was home, I was home. Dinner at the table, math homework, taking the trash out after everyone else had gone upstairs, sitting on the edge of a child's bed while they explained some playground injustice in great detail. But I was tired a lot, and because Natalie was capable, I let capable become in charge. That happened slowly. Most serious mistakes do. My mother still lived alone then in Tulsa, in the brick house she and my father had owned since the 1970s. After my father died, I drove down to see her every other Sunday when I was in town. Sometimes Natalie came with me. Sometimes the kids did. Sometimes I went alone with a paper sack of groceries on the passenger seat and a list of things my mother would insist she did not need. She was practical, small, steady, and not easy to embarrass. She kept her kitchen in the same order for 40 years. Even after her knees got bad, she still clipped herbs into a glass on the windowsill like she expected company. When she turned 80, Natalie began helping her more regularly. At the time, I thought it was generous. She would stop by in the middle of the week, pick up prescriptions, take her to the bank, help with errands, bring soup from a deli my mother liked. My mother was grateful for the company. She once told me over the phone, in an offhand way, that Natalie had become the daughter I never had. I remember smiling when she said it. I was driving home from the airport in light rain, wipers ticking back and forth, and I felt lucky in a plain, middle-aged kind of way. Then small things started coming up. Not alarms. Not at first. A silver serving tray my mother thought had been put away somewhere safe. A box of old Christmas ornaments that had been moved to storage. A pair of earrings that had belonged to my grandmother and were, according to Natalie, probably packed with other valuables so they would not get misplaced. Every time, there was an explanation. Every explanation sounded reasonable, and every time, I accepted it because the alternative was uglier than I wanted to name. The financial part showed itself by accident. I was home on a Wednesday afternoon, which was unusual. A storm had moved through that morning, and the whole house carried that damp, clean smell that comes after rain when the windows have been cracked too long. I was in the kitchen rinsing out a mug when my cell phone rang. The woman on the line asked for Natalie. I said she was not available and asked if I could take a message. There was a short pause, the kind people make when they realize they may have said too much already. Then she mentioned my mother's checking account and a transfer that needed to be verified. I did not say much after that, just enough to keep her talking, just enough to understand there had been movement in an amount that was not small, and that whoever had been handling the account was someone the bank expected to reach through my wife. When the call ended, I stood at the counter for a few seconds with the phone still in my hand. The dishwasher hummed. Water ticked somewhere in the sink drain. Outside, a neighbor was mowing wet grass, and the sound came through the window in dull passes. I called my mother and asked her a few careful questions. Then I went upstairs to my study, opened the top drawer of my desk, took out a legal pad, and wrote down 3 things. First, confirm the account access. Second, review the transfers. Third, say nothing until I know the shape of it. Then I set the pen down, and I waited. I did not confront Natalie that night. She came home a little after 6 carrying takeout in a paper bag, set her keys in the dish by the door, and asked me if the weather had been bad near the airport because she had seen standing water on the highway. I told her it had cleared by noon. She nodded, unpacked containers onto plates, and moved around the kitchen with the same easy competence I had watched for years. Nothing in her face looked strained. Nothing in her voice sounded different. That was the part that stayed with me. If there had been guilt or fear or even some clumsy effort to feel out what I knew, I might have spoken too soon. But there was none of that. She asked whether Evan had called back about bringing the kids over the following weekend. She reminded me the smoke detector upstairs needed a battery. She put soy sauce packets in the junk drawer because she said it was a waste to throw them out. I sat across from her and listened and understood that whatever was happening had been happening long enough to feel ordinary to her. That changed the way I thought. I have always been better with facts than with feelings. Not because I do not have feelings. I do. But facts stay where you put them. Feelings move. So I stayed with what stayed still. The next morning I called in late to a consulting meeting and drove to Tulsa. My mother was in the kitchen when I got there, wearing a pale blue cardigan and standing at the counter with one hand resting on the edge as if she had been caught in the act of doing too much. There was coffee on. The radio was low. Some man with a tired voice was talking about farm prices. She looked up and smiled when I came in, then frowned a little because I had not called ahead. "You're here on a Thursday," she said. I know. That was enough for her to understand something was off. I did not start with accusations. I asked about errands. I asked about the bank. I asked what Natalie helped with these days and how often. My mother answered plainly at first, then less plainly, then with the careful pauses of someone realizing that a story she had accepted might not hold together under simple questions. She said Natalie had told her it would be easier if she had power of attorney for errands and paperwork. Temporary mostly. Just practical. Groceries, pharmacy pickups, routine banking if my mother did not feel like waiting in line. She said there had been a few larger withdrawals over time, but Natalie had explained those too. Home repairs, storage, protection, simplifying. My mother's hands were folded tightly by then. Her knuckles had gone pale. I asked if she remembered signing the papers. She said yes. I asked if she had read them closely. She looked down at the kitchen table, at a faint ring left by a cold glass sometime in the last 10 years, and said, "I thought I was being helped." The room was quiet for a moment except for the radio. Then I reached over and turned it off. The refrigerator motor kicked on. A truck passed outside. Somewhere down the block a dog barked twice and stopped. My mother looked smaller to me then than she ever had before, and I did not like that feeling. I told her I was going to look into everything and that I needed her not to mention this to Natalie yet. I kept my voice even. No anger, no speculation, just sequence. She nodded. Then she did something that almost broke me. She said, very softly, "Did I do something foolish?" I told her no. I told her trusting the wrong person was not the same as being foolish. She turned her face away and cried once, quietly, and then she got up, rinsed her cup, and asked whether I wanted eggs because she had not eaten yet either. That was my mother. Even then, on the drive back, I called two people I had worked with over the years. Not close friends, not men I saw socially, but steady, capable people who understood what could be asked and what had to be documented before it was said out loud. My work life had never interested Natalie much. She knew the broad outline. Government work for a long time. Investigations. Retirement. Consulting after that. She knew I traveled. She knew I kept files. She knew I did not bring stories home. That was all. I had spent 21 years in federal financial investigations before retiring at 62. White-collar fraud mostly. Procurement cases. Internal theft. Asset tracing. The kind of work where the truth is usually sitting somewhere in plain sight, but under 10 inches of routine and paperwork, and people counting on no one looking long enough. I had been good at it. Quietly good. I do not say that with pride exactly. Just accuracy. There is a certain kind of patience the work teaches you. You stop reacting to what people say. You start paying attention to what leaves a trail. Dates. Signatures. Timing. Repeated amounts. New accounts. Storage leases. Insurance riders. Vendor invoices. Changes in address. Tiny habits that get built into paper. Once you know how to look, systems speak. Over the next few weeks, I gave myself rules. I wrote them down on a yellow pad and kept the page folded inside a legal folder in my desk. Step 1. Confirm access. Step 2. Preserve records. Step 3. Build the timeline before the conversation. That was it. No improvising. No emotional detours. No late-night confrontation because I had become too angry to sit still. I began with my mother's accounts. With her permission, I met in person with the branch manager at her bank. He was younger than I expected, serious, careful, and already uneasy by the time I sat down because he had likely realized the phone call the day before had landed in the wrong place. I showed identification. I explained who I was. I kept my tone neutral. Once people understand that you are not there to perform outrage, they often become more useful. He pulled records. I took notes. Transfer amounts, dates, withdrawal patterns, authorizations. There it was. Not one large, wild theft. Nothing that obvious. It was cleaner than that. Smaller movements spread over time. Just enough at each point to avoid drawing attention from anyone who was not looking across years instead of months. That is common. It feels safer to the person doing it. By the end of that first review, I had enough to know the problem was real. By the second, I understood it was larger than I had hoped. There were direct transfers, cash withdrawals, a few checks. There were explanations on paper, but not good ones. The kind that work until someone asks for support and discovers the support is another unsupported line item somewhere else. I kept copies of everything. I did not tell Natalie. At home, life continued in the same outward shape. That was one of the strangest parts. We ate dinner. We discussed the grandchildren's school fundraiser. She mentioned that one of her clients might want to expand a contract. I asked which client, and she answered with a company name I did not recognize. That caught my attention for a different reason. I knew she had been consulting. I did not know how much. I did not know the structure of it. I had assumed, with the laziness of a husband who thinks he already knows the broad facts of his own life, that it was modest and straightforward. It was not straightforward. A few days later, while she was out, I reviewed our shared account activity more carefully than I had in years. Not a quick glance. A real review. Patterns emerged almost at once. Transfers from our joint accounts to business accounts under her name. Vendor payments I could not identify. Revenue deposits that did not line up with anything she had described to me. Reimbursements without supporting expenses. Payment memos that were either vague on purpose or written by someone who thought vague was the same as normal. I wrote down each one. Date, amount, source, destination, notation. The house was quiet while I worked. Late afternoon light came in through the study window and hit the file cabinet beside the desk. I could hear the washing machine downstairs in its spin cycle, thudding a little because the floor under it had never been level. That sound took me back years. Children's soccer uniforms, school clothes, hotel laundry done in a rush between trips. Ordinary life carrying on while something else moved underneath it. I opened more records, then more. What I found was not chaos. That would have been easier. It was organized, intentional, spread across enough time to look natural if viewed in pieces. And like most organized deceptions, it depended less on genius than on confidence that no one would ever assemble the whole thing. That confidence had not come from nowhere. I had given it to her. There is no use softening that now. She had handled the household finances for so long that even I had begun speaking about them as if they existed in a part of the house I simply did not enter. She paid property taxes, renewed policies, managed contractors, balanced accounts, moved money between savings and checking when needed. I knew the outline and ignored the workings. At the time, I called that trust. In those weeks, I started calling it by its proper name. Inattention. That was harder to live with than the numbers. The first time I saw the storage unit paperwork, it came folded inside a stack of insurance documents. The rental was under a variation of her middle name, slight enough that I almost passed over it. Same phone number, different spelling. Facility on the north side of the city. I did not go there immediately. First I confirmed the contract dates. Then I checked payment history. Then I looked back through text messages and calendar entries until I found the recurring gaps that fit the drive time. Wednesday afternoons. The same day she had been helping my mother. I sat back in my chair and looked out the window for a while after that. Our backyard was empty except for a plastic ball one of the grandkids had left near the fence. The grass needed cutting. A wind chime moved once, lightly, then went still. I remember thinking, not dramatically, just clearly, that there are moments when a marriage stops being a private sorrow and becomes an administrative fact, not over emotion, over evidence. I waited 3 more days before going to the storage facility. It was in a row of low beige buildings behind a chain-link fence with a keypad gate and a faded sign near the office window. The afternoon was hot. Heat came off the asphalt in waves. Somewhere nearby, someone was using a leaf blower, though there were hardly any leaves to move. I parked, sat for a minute, and watched people come and go. A man loading restaurant chairs into a van. A young couple arguing quietly over a broken lamp. An older woman carrying a box with both arms under it like she did not trust the bottom. Ordinary traffic. Ordinary storage. Inside the office, the manager was polite but firm at first. Company policy. Privacy. Access limits. That is where experience helps. Not pressure. Not threats. Just the right sequence of questions, the right documents already in hand, the right phrasing to make clear I was not guessing and not going away. By the time I left, I had confirmation the unit existed, that it had been active for years, and that items had moved in and out on dates that matched several of the missing things my mother had mentioned. I did not open the unit that day. I did something better. I built the chain first. Then I went home, put the papers in order by date, and started a second folder. That evening, Natalie stood at the stove making soup and asked whether I could take a look at the hall light because it had started flickering again. I said yes. She thanked me without turning around. The smell of garlic and thyme drifted through the kitchen. The television was on in the next room with the volume low. She looked completely at ease. I went upstairs after dinner, sat at my desk, and opened the second folder. Then I found the appraisal receipt for a painting that had hung in my parents' living room since 1974. I knew that painting. It had hung over the sofa in my parents' living room for as long as I could remember. Not because it was especially valuable, though it turned out it was worth more than I would have guessed. I knew it because it had always been there. Christmas mornings. Bad news. Good news. My father reading in his chair. My mother hemming curtains with the television on low. Some objects become part of a family's memory without anyone saying so. The receipt was from an estate dealer across state lines. Appraisal first. Sale later. The dates sat there in black print, clean and calm, as if they had nothing to do with any of us. I did not react right away. I read the page once, then again. Then I set it beside the storage contract and looked at both documents together. That was the first time the whole thing stopped feeling like scattered dishonesty and started feeling like a system. Not one bad decision, not one boundary crossed in a weak moment. A system. I put the phone face down and kept working. By then, I had enough to know 2 things. First, Natalie had been using access to my mother's life as a route to money and property. Second, there was a very good chance she had been using the same confidence, the same habits, inside our own marriage. I turned to her business next. She had always described it in broad, tidy terms. Branding work, client strategy, project advising, a little travel, a few regular accounts. Nothing worth burdening me with, she would say, usually with a small smile, as if sparing me the boredom of details. I had accepted that because it fit the shape of our life. We had long ago settled into separate zones of competence, or what I had mistaken for competence. She handled the house. I handled my work. We met in the middle where families usually meet: meals, birthdays, repairs, holidays, grandchildren, weather, medication refills, the ordinary mechanics of getting older without saying much about it. But the records told a different story. Her consulting business had been active longer than I knew. Larger too. There were invoices from clients I had never heard of, deposits that moved quickly through intermediary accounts, and expenses assigned to projects that did not appear to exist outside the line items themselves. Some charges were small enough to ignore if you saw them one at a time. A business software subscription, a travel reimbursement, vendor fees, retainers, marketing costs. But when I laid them beside each other by month, then by quarter, the pattern sharpened. Money came in, money moved, money blurred. That is often all fraud is at first glance. A blur made to feel normal by volume. I requested corporate filings, registration records, and tax-related documents that were available through lawful channels tied to my consulting work. Nothing improper, nothing theatrical, just process, just paper. The business was in her name alone. That part did not surprise me. What did surprise me was how often our joint accounts had quietly supported it. Seed money at the beginning, operating cash later, payments for services and subscriptions, a leased office mailbox, travel, some equipment, several temporary transfers that never came back the other way. Enough that the distinction she had begun implying between her assets and ours was not going to survive contact with records. I created 3 binders. The first was my mother's accounts and property. The second was the business. The third was marital finances, the house, retirement accounts, joint savings, transfers, obligations, improvements, and the quiet ways one household funds another story. I did not decorate the process with emotion. I had learned a long time ago that anger is expensive. It burns time, and time is what organized people count on you wasting. So I worked, morning to afternoon, afternoon into evening. I ate when it occurred to me. The house settled around me with its usual noises. Ice maker dropping cubes into the bin. The dryer buzzing downstairs. A dog barking somewhere down the block at almost the same time every night. Natalie moving through the hall talking on the phone in the low, polished voice she used with clients. Once, she stepped into the study doorway and asked if I was coming to bed soon. I looked up from a spreadsheet I had printed and marked by hand. Soon, I said. She nodded and went back down the hall. There was nothing in her face that suggested she felt any shift at all. That became useful. A few days later, I drove back to my mother's house with copies of specific records and a short list of questions. I had learned over the years never to flood someone with everything at once, especially when the information is about their own betrayal. Too much detail can feel merciful to the person delivering it, but it is often only a way of emptying your own burden. So I asked what mattered. Did she authorize these transfers? No. Did she know of this storage unit? No. Did she give Natalie permission to remove specific household items for appraisal or sale? No. Did she remember signing anything besides the power of attorney? She was not sure. That answer mattered most. By then I suspected there had been more paperwork than she understood. Not forged, necessarily. That is not always how it works. Sometimes people sign exactly what is put in front of them because trust has been arranged in the room before the document ever appears. My mother listened while I explained only what I could already support. Her face changed very little. That was another family trait. We were not loud people in grief. We became careful. When I finished, she got up, opened a drawer, and handed me a small stack of envelopes bound with a rubber band. "What's this?" I asked. "Things I meant to ask about," she said. Inside were bank letters, insurance notices, a typed inventory sheet, and 2 handwritten notes in Natalie's neat block lettering reminding my mother not to worry because everything was being simplified. I read them at the kitchen table while the afternoon light thinned over the floor. Simplified. That word appeared more than once in the records too. People repeat themselves when they think language is protection. I took the envelopes home. That night I began building the timeline in full. Not just dates and amounts. Context. Who traveled when? Which child had been in college at the time? Which week my mother had a medical appointment? When Natalie opened the mailbox? When the storage lease began? When the first unexplained transfer appeared? When the business revenue increased? when certain household items disappeared from my mother's inventory, and when appraisal records surfaced. A timeline is a sober thing. It does not care about explanations. It simply places facts beside each other until coincidence becomes difficult to defend. Around midnight, I leaned back in my chair and knew I was no longer trying to understand what had happened. I understood it. Now I was deciding how it would be handled. That was the shift. Up to then, some part of me had still been a husband gathering painful information. After that night, I was working a matter. I called Russell the next morning. He had been recommended to me years earlier by a colleague who said he was exactly the kind of attorney people underestimated until paperwork started showing up. We met in his office 2 days later. Second floor of an older brick building. Faded carpet in the hallway. A receptionist who spoke softly without sounding timid. Russell himself had silver hair, rimless glasses, and the kind of blue tie that looked as if he owned several versions of it and saw no reason to change a useful habit. He did not waste words. I brought one banker's box and one leather portfolio. I set both on the chair beside me. He looked at them, then at me, then asked, "How long have you been collecting this?" "About 7 weeks," I said. He gave a short nod. "Have you confronted her?" "No." "Good." He opened the portfolio first. The power of attorney. Selected bank records. Appraisal receipt. Storage contract. A small summary sheet I had typed listing transfers by date and total amount. He read without interruption for several minutes, occasionally making a note in the margin with a mechanical pencil. The office was quiet except for the faint hum of an air conditioner and the sounds of traffic from the street below. Finally, he set the papers down, removed his glasses, and looked at me for the first time as if he had moved from intake to assessment. "This is unusual," he said. I said nothing. He tapped one page lightly. Unusual partly because of the overlap. Family misuse, elder financial issues, marital asset questions, undisclosed business activity. Usually these problems arrive one at a time. They didn't. No, he put his glasses back on. No, they did not. Then he asked me what I had done for work before consulting. I told him. Not the shortened social version. The real version. By the end of that explanation, he sat back a little and studied me in a different way. "That explains the binders," he said. I told him I had 3 more sections still being organized. That was the only moment in the meeting when he came close to smiling. He asked practical questions after that. Whether Natalie knew I was reviewing records. Whether there were risks to my mother's remaining accounts. Whether any joint assets might be moved quickly if Natalie sensed pressure. Whether adult children were involved or aware. Whether there were digital accounts still shared. Whether the house title had changed at any point. Whether I had preserved original copies were necessary. Yes. No. Partially. Not yet. Still shared. No. Yes. Facts. Sequence. Exposure. Russell stood and went to a file cabinet against the wall. He pulled out a clean legal pad, wrote 3 headings, and turned it so I could see. Immediate protection. Evidence organization. Response strategy. Then he sat back down and said, "From this point on, you do less, not more. No accusations. No emotional confrontation. No showing your hand because you want relief. We lock down what needs locking down, finish the record, and wait." I had expected that. Still, it was useful hearing it from someone else. He made several calls while I was there. One to discuss protections around my mother's accounts. Another to arrange a referral for a formal forensic review if needed. Another to flag potential disclosure issues if a divorce filing appeared before we acted. That last part got my attention. "You think she'll file?" I asked. Russell capped his pen. "I think people who construct parallel financial stories often become aggressive when they feel ordinary life tightening around them. Filing first lets them define the narrative before the records do." That stayed with me. I left his office with a shorter to-do list and more clarity than I had had in weeks. At home, I changed nothing visible. That was harder than the document work. Natalie and I went to dinner with friends one Saturday and listened to a long story about a kitchen remodel. She laughed at the right places. I passed the breadbasket. Someone asked how retirement suited me, and I gave the bland answer I always gave. That consulting kept me busy enough without making me put on a tie every day. Across the table, Natalie smiled as if she and I were still standing inside the same life. On the drive home, she asked if I thought we should help Evan with a down payment if he and his wife decided to move to a larger place. The question was almost surreal in its normalcy. "We can talk about it," I said. She nodded, looked out the passenger window, and that was that. A week later, my daughter Lila called. Her voice had that careful brightness adult children use when they are approaching something they do not quite want to ask. She said her mother seemed stressed. She said there had been some tension. She asked if everything was okay. I stood in the laundry room while we spoke, one hand resting on the top of the dryer, looking at a basket of folded towels I had not yet carried upstairs. Your mother and I are working through some things, I said. That was true, though not in the way she imagined. Lila was quiet for a second. Then she said, "Do I need to worry?" "No," I told her. "Not right now." I did not bring her into it. Not because I wanted to protect Natalie. That instinct had ended. I kept Lila out because timing matters, and because once children are placed inside a parent's secret, they do not get back out cleanly. After the call, I made one more adjustment. I changed passwords, separated access where I lawfully could, and moved copies of the key records out of the house. Not dramatically, not all at once, just enough. A banker's box to a secure office, digital copies to protected storage, originals in order, indexed, cross-referenced. I also added one more section to the timeline. Likely response behavior if challenged directly, if challenged legally, and if she moved first. I had seen too many people mistake exposure for resolution. Exposure is just the beginning. After that comes behavior. Then one Monday in March, Russell called before noon. His voice was as even as ever. "She filed this morning," he said, "and it's aggressive." I closed my eyes for a second, not from surprise, but from recognition. What does she want? The house characterized in a way that favors her. The business framed as separate. A reduced share to you of jointly built assets. Strong language about emotional absence and financial disengagement. I stood very still while he summarized the rest. When he was done, I asked only one question. Did she say I knew nothing about the money? There was a brief pause. "Yes," he said. "In substance, yes." I looked down at the legal pad on my desk, then at the row of binders lined up beside it. Blue, black, gray, everything in order. "All right," I said, and for the first time since that phone call from the bank, I felt completely calm. Then I waited. Once the petition arrived, the air in the house changed. Not visibly, not in any way a guest would notice. The dishes still got done. The mail still came at noon. The neighbor still blew leaves off his driveway, even when there were hardly any there. But inside the walls, everything had shifted from private strain to procedure. Natalie moved into the guest room that same week. She did it without discussion. One evening I came home from a meeting with Russell and found two of her suitcases by the hallway bench, the guest room door half open, and the faint smell of her perfume mixed with dust from a closet that had not been used much in years. She was in the kitchen rinsing berries in a colander. "I thought it would be simpler," she said. There was that word again. I nodded once. "All right." She looked at me as if she expected something larger than that. A challenge. A question. Some tired middle-aged argument that could be carried into filings later and used as texture. I gave her none. That seemed to unsettle her more than anger would have. From then on, our conversations became narrow and practical. Garbage pickup, grandchildren visiting, a package left on the porch, whether I was going to be home for dinner. We spoke politely. We also spoke less. At night, I sat in my study with the lamp on and the binders open in front of me. The house would settle around 10:30, making those small, familiar noises older houses make when temperatures drop, wood easing, vents ticking, a faint creak in the upstairs hall. I knew every one of those sounds. I had lived with them for more than 20 years. Now they felt like witnesses. Russell's advice was straightforward. Do not chase emotion. Do not answer accusations in kind. Build the response through documents, not speeches. Let her filing sit there and age badly while the record behind it becomes harder to escape. So that is what I did. I tightened everything into steps. Step 1, protect what could still be moved. Step 2, finalize the timeline. Step 3, prepare disclosure in a way that forced precision. I made a checklist and worked through it line by line. Accounts first. Access, beneficiaries, notifications, shared passwords, backup records. I changed what was mine to change. I documented what remained shared. I flagged items for Russell that required formal requests rather than improvisation. Process has its own dignity when you use it properly. It keeps you from turning pain into theater. My mother's situation moved on a parallel track. Her accounts were secured. Authority was narrowed. Copies of relevant bank records were preserved. A separate legal review was started regarding the transfers and any sale of property that had been arranged without informed consent. I kept my mother updated, but only with what she needed to know. She had enough to carry already. One Sunday afternoon, I drove down to see her. The day was bright but cold, the kind that makes the sky look polished. She had a pot of soup on the stove and a cardigan folded over the back of a chair because she always warmed up in stages, never all at once. We sat at the kitchen table with the paperwork between us. She asked careful questions. Not how could this happen? Not why would she do this? Those questions belong to another kind of person. My mother asked, "What do you need from me next?" I told her there might be a sworn statement later, that there could be questions about dates and property and what she understood when she signed the power of attorney, that someone might need her to walk through what Natalie told her over the years. She listened, then nodded. "I can do that," she said. Her hands were folded over each other on the table. The skin there had gone thin with age, almost translucent in the afternoon light. I noticed a small burn mark on the wrist from cooking, probably recent. Life continuing in the middle of all this. Then she asked, "Did your children know anything?" "No," I said. She looked relieved by that, though only slightly. Neither of us said what sat underneath the relief, which was that they had still believed the wrong things about me, or at least feared them enough to go quiet. That part had its own weight. My son, Evan, called a few days later. He was less careful than Lila had been. That had always been his way. Lila approached difficult things like she was carrying a glass bowl. Evan tended to put his hands straight into them. He said his mother was upset, said she felt I had checked out of the marriage years ago and was now trying to rewrite history through lawyers. He did not sound angry exactly, more frustrated, as if he had inherited a broken appliance from both of us and now had to decide which manufacturer to blame. I let him talk. There is a kind of discipline in not defending yourself too early, not because you are weak, because premature truth often sounds strategic. People hear it as counterattack, not clarity. When he finished, I said, "I understand why this looks confusing." He exhaled through his nose. "Then explain it." "I will," I said, "when the timing is right." That irritated him. I could hear it. "Dad, that sounds like something from work." "It probably does." He was quiet for a moment, then said, "I just don't want to find out later that everybody knew more than I did." That landed harder than he intended. I looked out the study window at the back fence, at a rake still leaning where one of the grandkids had left it after pretending to help the last time they were over. "You won't," I told him. It was the best I could give him then. After we hung up, I wrote down the call on the timeline. Not because it was evidence in the legal sense, because chronology matters to understanding. Family reactions become part of the weather system around a case. They influence choices, pressure, silence, and what a person thinks they can get away with. Meanwhile, Russell and I refined the response. His office became a second workroom for me. Same faded hallway, same quiet receptionist, same blue ties. I would bring updated files, and he would sort them into what belonged in immediate court response, what belonged in discovery, and what belonged in reserve unless the other side forced it into daylight. Reserve matters. You do not lay every card down just because you own the table. You place what is necessary, then wait to see whether the other side understands the part they're standing in. Natalie's filing leaned hard on the idea that she had built the family's financial life while I remained passive, detached, and minimally aware. She described her consulting business as essentially separate in spirit, if not always in form. She framed my work life as stable but ordinary, as if my main relationship to our marriage had been a direct deposit and a set of car keys. Russell read one section aloud in his office one afternoon and glanced up over his glasses. "She's gone too far," he said. I knew what he meant. A modest distortion can survive because courts see people shading themselves in better light every day. But large, confident misstatements become dangerous when records exist, especially when those records are clean. "What do we answer with first?" I asked. He tapped the table with his pen. "Not everything. Enough." So we chose carefully. A financial summary showing long-term commingling of marital funds with her business. Key transfers from joint accounts into business structures under her control. Documentation supporting my mother's property removals and account activity while Natalie held power of attorney. And one professional summary of my background that made it impossible to maintain the fiction that I was some inattentive bystander to 30 years of money. That last piece was not vanity. It was context. Silence reads one way until credentials are attached to it. Then people have to consider that the silence may have been deliberate. I did not enjoy that fact, but I understood it. At home, Natalie began testing the edges. Small questions first. Have you retained someone expensive? Is Russell the kind of lawyer who drags things out? Do you really want this to become ugly? I answered each one with less than she wanted. I have counsel. He seems efficient. I prefer it stay factual. That last answer made her set her water glass down harder than she meant to. Factual, she repeated. That's interesting. I looked at her across the kitchen island. Evening light was coming through the blinds and pale bars. The dishwasher was running. There was a dish towel over her shoulder and reading glasses pushed up into her hair. A domestic scene, almost peaceful, except for the current under it. Yes, I said, it is. She stared at me for a moment, trying to decide whether I knew more than she had assumed. Then she gave a short laugh that was not really a laugh and turned away. I did not follow. Then I waited. A week later, one of the sharper turns arrived. Russell received preliminary materials from her attorney, an older man named Corman who wrote with the confidence of someone accustomed to people settling before his assumptions had to be examined closely. The packet repeated her claims with more polish. It leaned into her sacrifices, her labor, her management of my mother's needs, her isolation, her burden, all of it arranged into a version of marriage where she had carried the structure while I occupied it. Russell called and asked me to come in. When I arrived, he had the packet open and marked. He pointed to one paragraph. Here. It described Natalie's years of voluntary service in support of my mother's household and finances. Years of voluntary service. I looked at the words and felt something inside me go still in a new way. Not rage, not even vindication, just stillness. Because that was the point where I knew this would not stay inside the usual boundaries of a divorce negotiation. Not if they kept saying it that cleanly. Not if they continued to place her management of my mother's affairs inside a framework of generosity and trust. They're using the wrong facts confidently, I said. Russell nodded. That happens. He slid another page toward me. A draft of our response outline. He had divided it into sections with headings that were almost clinical in their simplicity. Marital asset interdependence, undisclosed transfers, third-party property and fiduciary concerns, professional context and financial competence. I read through it without speaking. He had done exactly what I would have wanted him to do: remove heat, preserve force. Good, I said. He leaned back. There's one more thing. He told me the first hearing date. Tuesday morning. Family court. Downtown. A temporary matters hearing, procedural on paper, but one that would shape momentum if either side misjudged the room. I wrote the date down. After that, everything narrowed. I reviewed the selected exhibits, confirmed dates, verified page numbers, rechecked calculations. There is a kind of comfort in arithmetic when other parts of life have become unreliable. Numbers are not moral, but they are loyal. 2 nights before the hearing, I found myself alone in the kitchen after midnight. The house was quiet. The refrigerator motor had just shut off. Streetlight from outside made a faint square on the floor by the back door. I stood there with a glass of water and looked at the dark window over the sink. 30 years is a long time to be mistaken about the shape of your own life. That is a private grief, and there is no real shortcut through it. But grief and procedure can occupy the same person at the same time. I had learned that in other cases. People think clarity comes after feeling. Often it comes during. You carry both. I set the glass down and went back to the study. The next day, Lila called again. This time her voice was softer. She said her mother seemed certain she would finally be seen correctly in court. That phrase was Natalie's, not Lila's. I could hear it immediately. A borrowed sentence always sounds smoother than the person carrying it. I said very little. Lila asked if I was all right. I looked around the study. The neat stacks of documents. The clipped notes. The hearing folder already prepared by the door. A man's life reduced, for the moment, to chronology and paper. Yes, I said. I'm all right. She paused. You sound very calm. I am. That was true too. The night before the hearing, I put everything in order one final time. Gray suit pressed. Hearing folder zipped. Copies where they needed to be. Phone charged. Keys in the dish by the door. Then I sat at the kitchen table with a cup of coffee gone cool beside me and allowed myself 1 hour to feel the whole weight of it. Not the filings, not the money, not even the lies on paper. The deeper thing, being watched for years by someone who had mistaken restraint for emptiness. At the end of that hour, I rinsed the cup, turned off the kitchen light, and went upstairs. In the dark hallway, the guest room door was shut. I did not stop there. The next morning, I drove downtown with Russell's folder on the seat beside me and the city just beginning to wake around the courthouse. The courthouse always smelled the same. Old paper, floor polish, coffee carried in from outside and finished too fast in hallways. By the time Russell and I came through security, people were already gathered in loose, quiet clusters near the elevators, each one carrying some private version of dread and trying not to show it. My hearing folder felt light in my hand. That is one of the strange things about documents. A life can sit there in less than 5 pounds. Russell and I took the elevator to the 4th floor without talking much. He had the same blue tie on. I noticed that and almost smiled. Some men create stability for themselves in small, repeatable ways. I have always respected that. The family court hallway was colder than the lobby. Fluorescent lights, wood benches along the wall, a court officer standing near the double doors with an expression that suggested he had seen every kind of performance and had grown tired of all of them. Natalie was already there with her attorney. She wore a navy blazer and low heels. Her posture was exact, one ankle crossed over the other, legal pad on her lap, reading glasses in one hand. From a distance, she looked composed enough to be there on behalf of someone else. Her attorney, Corman, stood beside the bench speaking to her in a low voice while flipping through a tabbed binder. She looked up when we arrived. Not warmly, not coldly either. More like a person taking in a variable she thought she had already measured. I gave a brief nod and took my seat several feet away. That was one of the last ordinary moments of the marriage. Russell sat beside me and reviewed the hearing outline once more, though he already knew it by memory. He was not nervous, just precise. He pointed to 2 sections and quietly reminded me that if the judge asked me anything directly, I was to answer only what was asked, no more. "I know," I said. "I know you know," he replied. Then the doors opened and we were called in. Courtrooms look bigger on television. In real life, most of them are smaller and more practical than people expect. This one had pale walls, state flags near the bench, a clerk stationed to one side, and the same dry circulating air that makes everyone take small sips of water whether they want to or not. The judge entered a minute later. Judge Ellison, early 60s, maybe. Silver hair cut neatly at the jaw. Reading glasses she used only when she was actually interested in what was on the page. The courtroom stood, then sat. I had never met her before, but I knew her reputation in the general way attorneys talk about judges when they think clients are not listening. Careful, not theatrical. Patient until she wasn't. Corman opened first. He was smooth without being flashy. The kind of lawyer who believed credibility could be created by tone alone if the room had not yet had reason to resist him. He presented Natalie as the steady architect of the marriage. The one who managed the home, raised the children through my years of travel, handled the household finances, cared for my mother, and built an independent consulting practice through effort and discipline while I remained largely detached from the systems that sustained our life. He did not insult me outright. Men like him rarely do in court. They prefer arrangement to attack. He arranged me into a man who earned money but did not shape anything. A husband who stepped away from decisions. A father who was present in a broad logistical sense but not deeply engaged. A professional with a solid but unremarkable career, now leaning on process because the marriage itself could no longer support him. I listened without moving much. The judge asked 1 or 2 short questions about the property schedule and temporary requests. Then Corman called Natalie to speak. She moved to the table microphone and sat with the same controlled posture I had watched across dinner tables, school meetings, medical forms, tax season, and holidays. She knew how to sound reasonable. That had always been one of her stronger gifts. And she was good that morning. She spoke about years of carrying details. Contractors, school forms, travel calendars, college applications, household repairs, insurance renewals, medication list for my mother, appointment coordination, banking errands, storage, donations, simplification. She described my work travel with a kind of tired charity, as if she had long ago accepted my distance and built a functioning life around it. There was just enough truth in what she said to make the rest dangerous. That is how convincing stories are built. Not from invention, from proportion. She talked about her consulting practice in steady terms too. Hard-earned, self-built, separate in spirit, if not always in technical form. She said she had protected the family from volatility by being the only adult in the house who paid close attention to the real flow of things. At one point, Corman asked, "How would you describe your husband's contribution to the financial structure of the marriage?" Natalie did not answer quickly. She took a measured breath and folded her hands. "He provided income," she said, "but actual management, planning, and decision-making were mine. He preferred not to involve himself." There was a short pause. Then Corman asked, "And his understanding of the finances?" "Minimal," she said. "Not sharp, not bitter, calm." That landed in the room with more force than if she had raised her voice. I heard Russell turn one page beside me. I kept my eyes on the bench. The judge looked down at the file in front of her, then back at Natalie. "You managed the marital finances for how long?" she asked. "More than a decade directly," Natalie said. "In practice, longer." "And you also assisted his mother with her household and banking?" "Yes." "Under a power of attorney?" "Yes." Judge Ellison nodded once and made a note. Corman sat down looking satisfied in the cautious way seasoned attorneys do when they believe a hearing is proceeding on rails. Natalie returned to counsel table, and for the first time that morning, she looked at me directly. Not long, just enough to check whether I understood the position she had established. I gave her nothing to read. Then Russell stood. He did not begin with outrage. He did not call her testimony false. He did not perform disbelief for the court. He began the way good lawyers begin when they intend to win slowly. "With the court's permission," he said, "I'd like to address 3 practical issues raised by the petitioner's presentation this morning." Judge Ellison gave a slight motion with her hand. First, the degree to which petitioner's business has been represented as separate from marital funding. Second, the degree to which respondent has been portrayed as lacking financial competence or awareness. Third, certain fiduciary concerns involving respondent's mother that may bear directly on credibility and on how this court should evaluate the current requests. The room changed a little then. Not visibly, more in the attention. Russell walked the court through the first section with admirable restraint. Joint funds transferred into business accounts. Repeated support from marital resources. Expenses paid from shared accounts. Business structures presented now as independent despite long-term material dependence on marital assets. He cited dates, amounts, pages. Then he moved to the second point. He offered a concise professional summary of my background. 21 years in federal financial investigations. Senior work on complex tracing matters. Retirement into forensic consulting tied to financial litigation support. Enough to establish context. Nothing puffed up. Nothing dramatic. Judge Ellison stopped looking at the page and looked at me for the first time with active interest. Corman shifted in his seat. Natalie went still. Russell let the silence sit for half a second before continuing. "The petitioner's repeated characterization of my client as a man with minimal financial awareness is, at minimum, materially incomplete," he said. "And in light of the submitted records, it appears to have been strategically useful rather than factually accurate." Corman rose then, objecting in the mild formal language attorneys use when they know the point has already landed. Judge Ellison allowed Russell to continue within limits. That was enough. He turned to the third section. This was the dangerous one, and he handled it carefully. He did not accuse Natalie of crimes. He did not ask the family court to decide matters outside its lane. He simply informed the court that documentary materials submitted under seal that morning raised substantial questions about transfers from my mother's accounts while Natalie held power of attorney, as well as removal and sale of property from my mother's residence under a pattern not consistent with ordinary household assistance. He handed up a limited set of materials. Not everything, just enough. A summary chart, selected bank records, the storage unit documentation, the appraisal receipt, a timeline excerpt. Judge Ellison read in silence. No one else in the room moved much. This is one of the things people misunderstand about decisive moments. They do not always feel loud from the inside. Often they feel almost blank. The body narrows. Time becomes administrative. A page turns. Someone clears their throat. A pen is set down. Then the structure of the room changes. Judge Ellison removed her glasses and looked first at Russell, then at Corman, then finally at Natalie. "Counsel," she said to Corman, "are you familiar with your client's representations regarding respondent's professional background?" Corman stood. "I was aware he worked in government," he said carefully. The judge looked back at the materials. "The respondent before me is not simply someone who held a job and deferred all understanding," she said. "He appears to have spent a substantial career in financial investigations and now consults in forensic matters. That is not a minor omission where credibility is concerned." No one said anything. Then she tapped one of the pages lightly. "And that concern is not standing alone." Natalie had turned toward me by then. Slowly, not dramatic, just the kind of movement a person makes when recalculating in real time. Judge Ellison continued, "I also have before me documentation suggesting that while petitioner held power of attorney for respondent's mother, funds moved from the mother's accounts in ways that are not yet adequately explained. In addition, there are records reflecting storage and appraisal activity involving property apparently removed from the mother's residence." Corman asked to be heard. Judge Ellison held up one finger without looking at him, still reading. "When a party comes into this court seeking relief on the basis of superior financial stewardship," she said, "and the submitted materials raise substantial questions about commingling, undisclosed transfers, and third-party fiduciary conduct, I am not inclined to proceed as though those questions are incidental." That was the moment the room turned. You could feel it in the stillness. Corman sat back down, then leaned immediately toward Natalie, speaking in a whisper so low I could not hear the words. He no longer looked polished. He looked busy. Natalie's face had changed in a way I had not seen before. Not panic exactly. Something narrower. The look of a person realizing the story she had entered the room with would not survive long enough to be useful. Judge Ellison looked at Russell. "When were these materials provided?" "This morning, Your Honor, in accordance with the court's direction for supplemental temporary submissions." She nodded. Then she looked at me. Not for approval, not for sympathy, just direct assessment. I held her gaze and waited. That seemed to tell her what she needed. She sat back slightly in her chair. "I am going to recess briefly," she said. "When we return, I expect counsel to advise the court whether temporary issues can be reframed in light of the credibility concerns now before me. I am also going to state for the record that some of what I have reviewed may require attention beyond the narrow scope of temporary marital allocations." She looked at Corman when she said that, not at Natalie. That mattered. The clerk announced recess. Everyone stood. Russell and I walked into the hallway, without speaking until we reached the coffee machine near the elevators. It made the same tired, grinding noise those machines always make, as if each cup is personally offensive to the motor. He bought 2 coffees and handed me one. The paper cup was hot. The coffee was not very good. For a few seconds we just stood there with the courthouse moving quietly around us. Then Russell said, "You knew she'd built the case on that version of you?" "Yes." "And you let her file first?" "Yes." He nodded once, not admiring it exactly, but understanding the shape of it. "It's cleaner that way," he said. "It usually is." He looked over at me then, finally allowing himself the faintest trace of a smile. In the hallway across from us, Corman was speaking to Natalie in quick, low sentences. She had lost color in her face. One hand was pressed flat against the side of the bench beside her. Her legal pad sat untouched. I did not go near them. I drank the coffee, set the cup in the trash, and waited for the court officer to call us back in. When we went back into the courtroom, the temperature seemed to have dropped a few degrees. Nothing visible had changed. Same flags, same bench, same fluorescent light washing the wood flat. But momentum had shifted, and everybody in the room knew it. Corman stood first. He had lost the easy glide he came in with. He was still polished, still careful, but now he was speaking like a man measuring every sentence before letting it out. He requested a continuance so the parties could review the newly emphasized financial materials more fully and address temporary matters with what he called greater precision. Judge Ellison looked at him for a long second. "Greater precision would be welcome," she said. Russell did not object to a short continuance. That was part of the value of arriving prepared. You do not need to force a dramatic ruling when the other side has already begun backing away from its own narrative. You let retreat do its work. The judge reset the matter for 2 weeks and entered temporary restrictions that were, in practical terms, exactly what we needed. No material movement of disputed assets without notice. No changes to business distributions tied to contested accounts. No disposal of property potentially relevant to the filings already before the court. And a direct instruction that updated financial disclosures were to be complete, verified, and timely. Then she added one more thing. She stated for the record that the court had serious credibility concerns based on the discrepancy between the petitioner's presentation and the documents submitted that morning. Her phrasing was dry, very controlled, but it landed harder than anger would have. A judge does not have to raise her voice to narrow a person's options. That was the end of the hearing. Natalie left with Corman without looking at me. They moved quickly through the hallway, both of them talking now. Not whispering, talking. She was holding her folder too tightly against her side. I noticed that because it was unlike her. She had always preferred to look unruffled, even in private. Russell and I took our time. On the courthouse steps, traffic moved through the light at the corner in slow, ordinary lines. A bus hissed to a stop. Somebody across the street was walking a dog in a red harness. It was a weekday morning in the city, and the world had no interest in the collapse of one marriage. That felt right to me. Russell asked if I wanted to go over next steps then and there or later that afternoon. I told him later was fine. He gave a short nod. They'll come back different. I know. By that he meant the case, not the people. When parties walk into court with one story and walk out having seen the court's reaction to documents they did not fully account for, they do not usually return with the same level of confidence. They return narrower, sometimes more realistic, sometimes more dangerous, but almost never the same. I called my mother from the parking garage before I drove home. She answered on the second ring. How did it go? She asked. It went well, I said. There was a pause, then a slow exhale on her end. I could hear a television faintly in the background and the clink of a spoon against a cup. I'm glad, she said. I'll come down Sunday. I'll make stew. That made me smile a little. All right. When I got home, the house was empty. Natalie had not returned yet. I hung my suit jacket up, loosened my tie, and sat in the kitchen for a few minutes without doing anything. The refrigerator hummed. Sunlight had shifted across the floor since morning. On the counter near the fruit bowl was a shopping list in Natalie's handwriting, neat as ever, as if ordinary life had not just run into a wall built from dates and records. I did not touch the list. Then I went upstairs and started preparing for what came next. People think the hearing is the climax in situations like this. It usually is not. The hearing is often just the moment where everyone finally agrees, without saying so, what kind of case this really is. The real work comes after. In the days that followed, the change was immediate. Corman's office stopped writing in broad moral terms and started asking narrower procedural questions. They wanted time to review accounting, time to reconcile business records, time to evaluate documentation concerning my mother, time, in other words, to understand how exposed Natalie actually was. Russell was courteous and exact. He sent what had to be sent. He withheld what did not yet need to be handed over outside formal channels. He also made it clear that any settlement discussion had to account for three realities at once: the marital estate, the business commingling, and full repayment to my mother for the funds that had been moved while Natalie held power of attorney. That was the first time repayment appeared explicitly in writing. Once it did, the tone shifted further. I continued working through the records each day, but now I was refining rather than hunting, confirming valuations, checking chain of custody for documents, reviewing appraisals, organizing proof of which marital funds had gone where and when and under what description.